YouTube. It's on. Back with another one for you. And this one is a continuation of... Damn, I forgot to put the title here. The fuck is it called? Oh, court survival. The court survival. The court survival. The shit is live and raw. You see that shit? Fucking all timers kicking in right there. All right, look. So let's get started with this, man. Cause there's some pretty good stuff in this. So, what to expect? During this proceeding, the judge will politely ask you to stand up and identify yourself, and if you recognize the signature on the citation. Now, look. So, signature on the citation. Of course, he's gonna ask you if you sign that, because that's an indication of you choosing to enter into a contract with them and get fucked. So he's going to ask you if you have a signature on there. They're also going to ask you in court when you first walk in. They're going to have you fill out a paper that says how much you make, if you're on any public assistance, if you're on food stamps, and guess what else they want? Your fucking social. So they want your social for what? For what? Think about that. So then you will be carefully informed of the charges against you, and the judge will attempt to steer you into an entering plea. And if not, right, the motherfucker will just make the plea for you and go ahead and practice law from the bench and just get it done, right? However they got to get it done. So the judge will also make it a point to find out if you intend to hire an attorney, i.e. if you have money, or if you intend to represent yourself. Right? He doesn't give you all the options, because why doesn't he ask you if you intend to settle the matter privately also as well, right? Like, what the fuck, bro? They only give you the options that they want you to pick from. Let me just put it like that. So you will notice that the officer who cited you is present, and you will be able to sense their attempt to process you like a head of cattle on the way to the cash register slaughterhouse. And that's really what this shit's all about. It's all commercial. You look at what these people are. You get their DUNS number, the EINs. They're all for-profit corporations, all right? So, of course, it's a cash register. All that they do is deal with commerce. That's all that they have the right to regulate. So they try to make everything a commercial transaction, a public transaction, in order to try to lure you into their fucking jurisdiction. Still fraudulent in nature anyway. You know what I'm saying? So, maybe it isn't, right? Because we all have choices, don't we? So they will try to make you believe that you have to do exactly what the judge tells you to do and that you have no other options. And that's funny, too, because when I was in court, too, I had supervision at one point. I was in there, and my PO was trying to violate me, and I haven't really gave a fuck since I was a teenager. Like, there was no fucks given, there was no filter. It's been raw. So I'm going in there to a violation hearing with my PO, and who the fuck was it? I think it was one of the lawyers there, and he was like wondering why I wasn't scared and all that, and I'm like, look, she can go, my PO can go in there and ask for whatever she wants. Ultimately, it's going to be up to the judge. You know what I'm saying? And my fucking PO was way out of line. The judge handed her fucking ass too, mind you, right? So, and he's like, damn, this isn't your first time either, right? And me bragging like, haha, yeah, I've been through this a few times. And shit ain't funny, to be honest with you, but it does teach you a lot of valuable lessons that you can't get unless you go through those situations. So I'm grateful nonetheless. But still fuck them all, right? So they will try to make you believe that you have to do exactly what the judge tells you to do and that you have no other options. Careful, as soon as you open your mouth to answer their question, you are allowing them the jurisdiction over you. If you enter a plea, you will be giving over your formal implied consent that you are under their jurisdiction. What to do? You have many options at this stage. If you intend to win in court, it is recommended that you challenge jurisdiction right away, because if you don't, they will deny you another chance. Below are a few strategies that we have learned, some of which you may feel comfortable using, all of which are designed to assert and exercise your legal rights. Now, I'm not going to recommend shit. I'm just reading this book to you so you guys can get some ideas in case you decide to. There's nothing against that if that's what you want to do. I spent a lot of my life dealing with these fucking people. I'm not trying to even speak to them, to be honest with you. So I choose not to. And if I had to do something one way, I would just go ahead and deal with the matter commercially using equity and settle the matter that way through the accounting, via the fucking accounting. So strategy 0. Hire your own licensed court reporter. Use this basically regardless of and in addition to any other strategy that you use. Hire your own licensed court reporter if at all possible. He or she should not be connected to the court you are going into, right? And that's a big thing too, is that, like, you walk into the courtrooms and it's everybody against you and they're all getting the fucking paid from the same place. So if that's not a conflict of interest, I don't know what the fuck is. So there must be no risk of record tampering by the judge. If this is not possible, be sure to bring plenty of friends with tape recorders. There is no law which prohibits you from bringing your own court reporter or tape recorder. So when your case is called, just announce that there is an undoubtedly need to appeal and that you want the record to start now, and you insist on using your own court reporter. If the judge tries to weasel out of it, then reassure the court that your reporter is licensed by the state and the judge has already established a court of record. There should be no legitimate objection, shoot down, or any lame excuses. Make a stand here. And there is a good chance that the judge will dismiss the case right there when he or she realizes that they can't lie if they need to and then get away with it by altering the court record, which is a regular fucking practice of theirs. So, strategy one, stand on the Sixth Amendment and expose the truth. This is by far the most effective and successful strategy we have seen. And it is simple enough for anyone to master, but there is some details that you will have to know cold. So here are using the facts that they can't reveal their own fraudulent admiralty jurisdiction. It is their most important secret to protect and keep off the record. Most of them are in fear of losing their licenses and jobs, for they have all been secretly sworn by the bar never to reveal it in open court. But with this strategy, they have to reveal it just to proceed with the case against you, because you must have answers to your questions. It is the duty of the court to inform you of the nature and cause of the accusation, pursuant to the Sixth Amendment, and this is your greatest strength. And that's a big thing right there, man. That's a big thing right there, man. So when they ask you if you understand the charges against you, you must say no. You will be standing on your Sixth Amendment right to be informed of the nature and cause of the accusation. Then you will be steering the judge through a very careful series of questions about the nature and cause of the jurisdiction. You are going to force the judge to expose the court's fraud in order to proceed with the case against you. So the judge, which obviously invalidates their whole claim to begin with once they admit that they're operating fraudulently, which is why they, try their best not to get that shit on the record. So the judge will have to dismiss the case. There is simply no other way for them to deal with this strategy, provided you stand your ground and you are going to be real polite and courteous. The step, they have to ask you if you understand the charges. So understand, you flip the word is stand under, and it does have meaning, all right? So there's no way around it. They cannot legally proceed against you until you acknowledge the charges explicitly. So, and that's why they always ask you, do you understand the charges that are being brought against you? And they'll just keep on fucking asking you. Because one time this dude tricked me into even fucking saying, yeah, I kept saying, yes, I comprehend. And then at the end, he fucking tricked me into saying that, like, I understand. And then that was the end of that fucking court case. That was the end of that hearing. You know what I'm saying? So, there's a lot of losses here too, bro. It ain't always wins, but you got to fucking start somewhere. So jurisdiction, implicitly, the Sixth Amendment says that you have a right to know and the authority to require the court to explain, and the court has the duty to explain. And that's the thing too. So when we're sending all these documentations, the Promissory Estoppel and things like that, what you're going to notice is that these people will silently acquiesce to all of your demands because they are servants, and they really can't go against the constitutional challenge that they signed an oath to, right? So the point of that is that they do have a duty to explain if they're not going to be able to perform up to your standards based on the contract that you send them. They have an obligation to let you know if what you're doing is illegal and there's going to be an issue with it, or if they're not able to help you in general, or if they stand against that ideology totally. But they do have a duty and an obligation to respond to you. So when they don't, what you end up with is a valid enforceable contract against them that they silently acquiesce and agree to. So there isn't going to be much of a court case if you were ever to move forward against these people, because they already agreed to your stipulations by silent acquiescence. So by you declaring that you do not understand the charges, you will steer the judge, the court, into a legal position where he or she must answer all of your questions. Then you will hang the judge up with the questions using his or her own rules of procedure. This is where the sheep outsmart the wolves. And I wouldn't even call them wolves. They're just men in black dresses, to be honest with you. That's what the fuck that these people are. So the plan. The following diagram is a picture showing a summary of the strategy and several paths of argument that it may take. Since every judge is different and there are some decisions and answers to be made, there are going to be several possible ways for this to go. We suggest you study this plan until it becomes crystal clear, so that you can completely understand how it all works. It must make sense to you in all forms and angles so that you will always be able to outthink the judge. You will be able to see and respond to their fraud in his every move when you are so clear that you don't even have to stop to think about your own moves. The judge will try to evade your plan by not really answering or outright lying. So you must steer him back into the plan, follow and study the logic described below according to the diagram. Step 1. So forcing the judge to answer your questions. So when the judge asks you if you understand the charges against you, you say no. The judge will then probably try to intimidate you by explaining them again in a condescending or stern voice, or implying that you are lying. So here is where you must politely present your need to have the answers, so that the judge must decide to answer your questions. The judge will have to ask you exactly what it is that you do not understand. No problem, just reply. Announcement number 1. Your Honor, the Sixth Amendment to the United States Constitution grants me the right to know the nature and cause of this action you are bringing against me, and it grants you, the court, the duty to tell me. So I do not understand the nature and the cause of this action which has been brought against me. The judge will have to allow you to ask him or her questions, no exceptions. The judge will probably say, what is it that you would like to know? Motherfucker, like, you didn't just say it, but they're going to play stupid because they have, look, plausible deniability is their only cloak that they have, aside from the fact that the freaking public immunity by following their guidelines or whatever, which they never do either, by the way. So arraignment, start here. J, do you understand the charges? No. What do you not understand? Announcement. Your Honor, the Sixth Amendment grants me, etc. Okay, what is it you would like to know? Is this a criminal or civil action? So that's what it is. So the judge asks you, what would you like to know? And what you would like to know is this a civil or criminal action? Because getting to the bottom of the jurisdiction that you're being charged under is going to allow you to set up a fucking defense, and they don't want you to have one, because then they fucking lose. Really, any defense they fucking lose, unless you argue with these people. But anything, it's crazy. Objection. Let the record show. Criminal action, wrong court, etc. Dismiss. So you put a motion to dismiss. So here we go. Question 2. The Constitution grants 2 criminal jurisdictions. Which one is this? The judge panics, the judge stalls, and he runs and he lies and shit. Dismissed plan A alternate. So apparently that was plan A, right? Asking them those type of questions, which I think if you bring a court reporter and you ask them these questions, I don't think that's just going to go past 35 seconds, to be honest with you. So plan B, let the record show. Criminal action under. J, go see attorney. Let the record show. Common law jurisdiction. Action comprising condition of contract under criminal aspects of admiralty. So these people are just making statements here in order to look. So basically the way that they're speaking is as if there was a transcriber there, which is how you should be operating in there. So look at it like it's going to be like a thread of a text message, something like that. Something along those lines. So here they're just running through what the basic verbiage would be there, but it's too choppy. I'm not going to sit there and fucking read that nonsense. But you can get the book, check it out, man. Get the book, check it out. Email me if you need it. So right here, so step 2. So step 2, steering with the questions. So now that the judge has agreed to answer your questions, he or she must answer all of them until you are satisfied that you are fully informed of the nature and cause. If he or she tries to back out of this decision, then you must point out the agreement that has already been made and you intend to keep it. Start out with a simple and indirect question of the nature and the type of case. You will lead the judge into a corner. So question 1, is this going to be a civil action or a criminal action? If the judge answers that it is a civil action, not likely, because he's not likely to reveal the fact that it is civil in nature, then you must immediately object and then move for dismissal. The reason here is that you are now in the wrong court. The state cannot bring a case against you and judge its own case. It cannot be both party to and judge of their own action. On the other hand, because that's a conflict of interest, if the judge answers that it is a criminal action, most likely he will say it's a criminal, then you can make the following announcement on the record. Thank you, Your Honor. Let the record of this court then show that this action against XYZ is a criminal action. Now I have another question. Question 2, Your Honor. The Constitution grants this court 2 different criminal jurisdictions. One is a criminal jurisdiction under a common law, and the other is a criminal action that constitutes a condition of contract under the criminal aspects of a colorable admiralty jurisdiction. Under which of these 2 jurisdictions does court intend to try this criminal action? So basically, what you're doing here is you're giving him the three different. Well, so, I mean, so here we have two. I mean, really it's three, but it folds down into two. So you get the maritime, admiralty, and common law. So those are gonna blend anyway. The admiralty and maritime are gonna fucking blend. So one is a criminal jurisdiction under the common law, and the other is a criminal action that constitutes a condition of contract under criminal aspects of a colorable admiralty jurisdiction. Under which of these two jurisdictions does the court intend to try this criminal action? So not wanting to answer this, the judge might just dismiss the case now, but most will try to go ahead with it. The only choices now are to admit which jurisdiction to apply or to avoid answering, get an answer though. So if the common law jurisdiction were to be declared, then you win by default of no sworn complaint by an injured party, because it has to be an actual victim, right? Corpus delicti, that's where you're going to find your actual tangible physical victim that has had harm done to them or damages, and no injured party present. So there is no evidence at all of you interfering with anyone's life, liberty, or property. The case must be dropped. If instead the admiralty criminal jurisdiction were to be declared foolishly, then you must be prepared to follow alternate plan B. Therefore, most likely here is where the judge will probably start squirming and just try to avoid answering, which I can see happening for sure. If you've ever been in a court, these people are not really that, they're really not that slick in there. The superior court judges, and then you get into the Supreme Court, those motherfuckers are a lot more serious, and I don't think that they would start down at the district, but maybe they do. You know what I'm saying? Who knows? But that's where you're gonna find your real fucking judges, the ones that have the books open on their desk. Those are the fucking real judges. That's an actual court of record. That's where you want to be. You know what I'm saying? Open the fucking book, bro. Because I mean, really, who cares about these people's personal opinions? Which is pretty much what they do all day. Just give their personal opinions on shit. So you get a licensed attorney for such legal advice. So like that's what the book says. I'm not advising you to go do that. So unless you don't know what you're doing. So announcement 2. So thank you, Your Honor, but I don't think that that you'd be violating your oath of office if you did your duty under the Constitution. You see, I am not seeking legal advice. What I want to know is your legal intent, and I have the right to represent myself in my own person. Propria persona, that's what that is, in my own person. I have the right to represent myself in my own person without a licensed attorney. And in order to intelligently defend myself, I have to know the jurisdiction that this court is operating under, because the rules of the criminal procedure under a common law jurisdiction are very different from the rules under an admiralty jurisdiction. I need to know which jurisdiction you intend to try me under in order for me to proceed with this case. Now, the Sixth Amendment grants me the right to know the jurisdiction being applied, and it grants you the duty to inform me. And I don't think you'd be violating your oath of office for doing so, and so please answer the question. The judge might dismiss the case here, but will probably continue stalling. He or she is most likely to reprimand or threaten you for not getting a licensed attorney. The judge will imply that that only licensed attorneys have this information, that you have to go see a licensed attorney in order to get the question answered. When this happens, you say, "Thank you, Your Honor. Let the record of this court then show that I, XYZ, the accused in this criminal action against me, have asked this court to divulge the nature and cause of this accusation upon the authority of the Sixth Amendment, and that this court has failed in its duty to inform me of the nature and cause of this action. Furthermore, let the record also show that this court intends to bring this criminal action against me under a secret jurisdiction that is known only to licensed attorneys." Oops, here is where a lot of judges will dismiss the case for whatever phony excuse, but there will also be some dickards asking for more embarrassment. If the judge is still onto the case here, he or she will have to come up with the answer for question 2. He or she will probably make something huffy up like, "This will be a statutory jurisdiction, and I hope you're satisfied." So now, reply, "Thank you, Your Honor. Let the record show of this court then show that it intends to conduct a criminal action against me, XYZ, under statutory jurisdiction. But the problem is that I have never heard of such a thing as a criminal action under a statutory jurisdiction. So I would be happy to accept this offer, Your Honor, if you could please tell me where I could find the published rules of criminal procedure under statutory jurisdiction." It doesn't fucking exist. So most judges are likely to give up and dismiss the case here, but some might still be hanging on. If your case isn't dismissed yet, then you might ask question 3. Do you have a copy of the rules and criminal procedure under statutory jurisdiction in your office that I could borrow? Where does this nature, cause, and jurisdiction information exist? Do you know of a law library anywhere that has a copy of these rules? Since I am defending myself pro per, isn't it your duty to specify which rules of the game that you are playing by? And it is a game. So keep that shit in mind, and these motherfuckers do not play fair. I mean, I guess they don't have to because they don't, right? So there it is. So definitely gotta know the rules of the game. Study, study, study. This book, I think, is gonna help a lot of people immensely. Take your time, listen to this shit. If you need the book, email me. It's on the house. That's what I got for you for now. It is a game of chess. Stop playing checkers with these clowns. Almost forgot that. That's what I got for you for now. That's what I got for you for now until we meet again.